Alright, Chapter 16, Part 244, Chapter 16, Part 240, Qualification, Certification, and Locomotive Engineers. Chapter 16, Part 240, Qualification, Certification, and Locomotive Engineers. General guidance. The FRA is not involved with the actual certification process of the individual engineers. The final ruling established minimum qualification standard for the locomotive engineers is a certification program, not a licensing program. In summary, the rules are required with the railroad to have the formal process of the evaluating process for prospective operators for locomotive determine that they are competent before the permitting with them to the operating locomotive or train. The rules require the railroad to make a series of determinations about the person's competency to advise the adherent. Here, the FRA approved the training program for the locomotive engineers, employed the standards method and divided with the qualified locomotive engineers monitoring their performance. Suspending a certification occurs when the engineer has notified the railroad is considered a revocation of his or her certificate. Remove the certificate occurs the hearing after an engineer was signing of the waiver usually occurs after a suspension. Qualification certification final ruling on February 22nd, 2010. The final ruling was issued in Title 49 CFR Part 240 Qualification Certification of Locomotive Engineers 74 FR 61873, December 23rd, 2009. In addition, with the making the minor corrections updates, the rules made for the following substantive change with Part 240 prohibited the railway from reclassification of person locomotive engineering certificate to that more restrictive class of the certificate to a student engineering certificate during the period of the certificate is otherwise valid. Required the railroad to indicate with the certification program type of actions it will take beyond prohibiting the engineer for the operating locomotive until the test is passed and the person fails the skill performance. Required the railroad to describe in the certification program the scoring the system as it will use during the skills performance to test the administrator in accordance with the statute 240-211, including a description of the skills to be tested, weighted of the possible score for each of the skill will be given. Required of the railroad to indicate the certification program type of the actions it will be taken to find the deficiency of the engineer performance during the monitoring ride or evaluation, unannounced operational rule efficiency test administration in accordance with the procedure required in statute 24303. Clarified that the railroads may revoke an engineering certificate only for the conduct specifically identified in 24117, also known as 6 cardinal rules. The final rule also stated with the changes of material modifications of the program, it will not be necessary for the railroad to resubmit their program to the FRA approval. However, the railroad be accepted to these changes made in the program at the effective date. The inspector who short line railroads should advise that the required changes simply process others provide with the FRA approved standard short line engineering certificate program that includes the required changes to the public information. The qualification, certification, and locomotive engineers can be found on the FRA website, fra.gov. Subpart A, General 243, Application for Responsibility for Compliance, Inspector Guidance for the Tourist Railroad. For the Tourist Railroad that do not operate with the General Railroad System, that those do not own the track, that the part of the General Railroad System, insular or non-insular inspections should reference the FRA General Manual specifically for FRA exercise jurisdiction decision tree. 247. Definition of locomotive means a piece of the track equipment other than a specialized road maintenance equipment, dual purpose the vehicle operating in accordance with statute 240-104A2 with one of the propelling motors designed to move the other equipment, one or more propelling motors designed to carry the freight of the passenger traffic, or both without propelling motors with both one or more of the controlling stands. Locomotive engineer is any of the person who moved the locomotive, the group of locomotives, regardless whether the coupled or on to the other rolling stock, except for the person who has moved the locomotive or the group of locomotives with the confines of the locomotive repair servicing as provided with the statute 218.5 and 218.29A1. A person who moves the locomotive or group of locomotives for the distance less than 100 feet incidental movement of the locomotive. The locomotive is for the inspection maintenance purpose. Subpart B. Component elements of certification program 240-103, the approval of the design individual railroad program. The FRA, the railroad must submit to the Part 240 program for the FRA to review the approval. All modifications of Part 240 of the program must be approved before the railroad can implement the program. 240-104, criteria determining whether the movement of the roadway maintenance equipment of the dual purpose of the vehicle requires a certified locomotive engineer. Regarding the Part 240, the non-certified employee will manipulate the switches, levers in the cab of the locomotive in relation to securement, air brake test, etc. 240 addresses the operation of the locomotive only, does not address the manipulation of the levers, switches while the equipment is standing. Therefore, any of the employee manipulating the controls of the standing locomotive does not need the necessary and is not necessarily needed for the Part 240 certification, although the regulations apply. Locomotive operating roadway maintenance equipment. Now, note that all road remote control locomotives or locomotives operated outside the mechanical facility require a certified locomotive engineer. The regulations noted above exempt certain functions such as one in the picture below. The train in the photograph above was operated via the RCL main track near Lincoln, Nebraska. The train backhoe operator was picking up the railroad ties along the track. The FRA considered the roadway maintenance equipment. Therefore, the Part 240 regulations did not require the remote control operator of the RCL to be certified. All right, 240-105, designation supervisor, locomotive engineers, contractors, number of the injuries that have been regarded with the use of the outside contractor certification purpose of temporary use and third-party engineers, such as during the workshop stop, the use of the service continuing engineers during the recent major labor disputes of the raised mania. The question policy, Section 5, Appendix B, the regulation making the provisions to take the training companies to the exit and the railroad to use the company's actual certification must be done by the railroad. Any outside contractor, how the contractor will be used and described in the railroad plans. Contractors will offer railroads temporary engineers, most likely by a temp agency offers the temporary employees in the field of work, certain accepting the business under Title Part 240. Or the problems raised by the outside contractors involved with the fact that the railroad can qualify the locomotive engineer under the Part 240. However, the contractor can be useful to a railroad by offering persons with experience testing of the person's knowledge of the certain required criteria, including some of the required background checks. For example, the contractor may check the prior safety conduct of the motor vehicle operating rules, compliance data on the substance abuse disorder, alcohol, drug rule compliance. In addition, the contractors may ensure the compliance with the criteria for the vision, hearing, acuity, initial, continuing education, testing, knowledge, examination, skill, performance monitoring, operational performance. Railroads must contain and use to meet the maintenance records requirements disposed by the regulation. When the railroads are free to work these contractors, railroad remains liable for the compliance with the regulation. One or more of the temporary engineers employed with the certification service could be certified. Multiple railroads carrying multiple certificates. Each certificate would have to be issued by the railroad, but not by the contractor or non-railroad entity. For each of the certificate remain valid, but the certificate holder would have the remain current of the issue railroad, i.e., any of the annual check, ride, and operational testing. An ordinary circumstance, railroad would require a minimum of 2 certified locomotive engineers. Each locomotive engineer could use the performing monitoring check rides of the other. However, by using the contractor or short line could achieve the compliance without employing 2 certified locomotive engineers. For example, the short line railroad with a certified employer could contract the certification service. The certification service could conduct all the testing checks of the railroad engineers as well as the certification service employee. The certification service employee could conduct the required annual check ride for the railroad engineers as long as the railroad engineer did the same for the certification service employee. Railroad must continue to meet the maintenance records requirements imposed by the regulation. 240-107 criteria for the design of class services. A railroad may issue certification for any of the following class services: train service engineer, locomotive service engineer, remote control locomotive engineer, student engineers. Each of the railroad authorized to impose additional conditions, operational restrictions. The service engineer may perform beyond the identified with this section, provided those conditions of restriction are not inconsistent with this section. Alright, student engineers. Students engineers with operating with the conventional locomotive on the cab, operating with the RCL from the ground, must be qualified locomotive engineer training in the position, taking immediate action to prevent the student engineer from making dangerous errors. Consequently, the RCL acting the instructor of the student RCO during the switching operation must be in position, taking immediate action when the notification of locomotive engineer. If the inspector finds the student RCO and the RCL without the qualified RCO instructor meeting the student to make an immediate action to prevent the potential dangerous situation, the rule violation, the inspector should take exceptions to the RCO inspector. The requirement of locomotive engineer trained to be positioned to take immediate action during the operational locomotive includes the situations such as a conventional cab locomotive when the student locomotive engineer is operating the locomotive, the instructor locomotive engineer is in the restroom. The conventional cab locomotive when the student locomotive engineer is operating the locomotive, the instructor locomotive engineer does not have the situational awareness, e.g., reading or sleeping, etc. The RCL operation when the Student of the RCO operating the RCL while the constructor is riding on the side of the railroad car. The student is riding on the other side of the railroad car. The RCL operations of the student RCO operating the RCL while instructing is the distance away from the performing of their specific duties of the restricted tasks. The place instructor in a position where he or she can take an immediate action in emergency. Student remote control operator with the belt packed in the remote control locomotive. Note that there is no trainer near him. Civil penalty recommended. FRA policy: more than one class of the service of the same certificate. The FRA does not intend the railroad to issue two certification documented when engineers are certified in more than one class service. The endorsement of the locomotive servicing certificate supplementary documentation is sufficient to reflect the person's status as a student training service engineer. The intent of the provision when the locomotive servicing engine documentation describing the functions as a student operates under the immediate supervision of the instructor engineer. It set into the interpretive question generated with the desire of some of the railroads to certify the person the train service engineer of the imposing significant limits to the constraints of the operational authority of the person. Section 240-107 permits the railroad to take such an action that can be employed to take by them to address the issue, such as using the person who has sufficient skills to perform the terminal yard services but lacks knowledge of the skill operating train yards. Terminals railroads elect to follow the approach will, of course, need to structure their implementation program submissions to reflect the differences in the training and the testing of the engineer that would be flow them with more limited operational responsibility. Locomotive movers work inside a designated mechanical facility. The engine employees of the moving locomotives inside a mechanical facility are usually not required to have an engineering certificate. They may be covered by the regulations of enforced operational practice, such as hours of service, Part 218, etc. There are two exemptions permitted, but that regulation include the locomotive engineer certificate is not required. A person who moves the locomotive or group of locomotives combined with the locomotive repair or service area provided in the statute 218.5, 218.29A1 guidance inspector should ensure that all area meets all the requirements stated in 218.5 and 218.5F and 218.29A. 1. A person who moves the locomotive group of the locomotives the distance less than 100 feet when incidental movement of the locomotive and locomotives for the inspection maintenance purposes. Alright, 241.11, the individual responsibility to furnish data on the prior safety conduct of the motor vehicle operator. The FRA has received questions from the railroad labor management regarding the requirement that the individual seeking engineering certification must furnish data on the prior conduct of the motor vehicle operator pursuant to Title 49, Part 240 of all reference provisions, Part 240 or provisions of Part 240 as amended to the date. The general requirements of Section 240.111, the individual duty to furnish the data of prior safety conduct of the motor vehicle operator stated to the circumstances that are not relevant for the instance of each of the persons seeking the recertification must do the following within 366 days preceding the date of the railroad decision of recertification. 1. Requesting the writing of the chief driver license agency that issued the application driver 2 license provided with a copy of the agency's available information concerning the application driving record of the railroad concerning the recertification. 2. Requesting written in the chief of the description driver license agency any of the state that issued or reissued the application driver license when preceding the 5 years provided a copy of the information concerning the application driving record of the railroad that is concerning with recertification request the chief of the National Driver Register of the National Highway Traffic Safety Administration performing a search of the National Driver Registry database identifying additional information concerning the application driving record the resulting information provided with the railroad considering recertification. Title 49 CFR 240.111 BD. Question 1. What must a Mexican citizen who has never been held a U.S. driver's license do to fulfill the requirements of 241.11? Pursuant to 241.11, a Mexican citizen without a U.S. driver's license must request a copy of the available information concerning his or her driving record, chief driver license agency of the United Mexican States that last issued applicable driver's license. Such a person must also request a copy of the available information concerning his or her driver record, the chief of the driver's license agency, any other jurisdiction in Mexico elsewhere there is issued applicable application driver license within preceding 5 years. See 241.11. Such an application must also request 241.11 D for the National Driver Register database search for any result of information provided by the railroad considering recertification. Question 2. Must all Canadian citizens who has never held a U.S. driver license do fulfill the requirements of 240.11? Canadian citizens who have never held the U.S. driver license who wishes to be certified in Part 240 must request a copy of the available information concerning his or her driving record of the chief driving license agency in the Canadian provinces that issued the application driver license. Such application must also request a copy of the available information concerning his or her driver record for the chief driver's license agency of any other jurisdiction, Canada, elsewhere issued the applicational driver's license within preceding 5 years. C24011 111 C2. Such application must be also requested by 24111 that National Driver Register database searching that any result information provided with the railroad concerning certification or recertification. Question 3: What must an American citizen who within preceding 5 has held the driver's license with another country do in the following requirements of statute 24111? In addition, with requesting a copy of the required information from the chief of the driver license agency in the United States, the last issued application, the driver license applicant must also copy of the required information for any of the jurisdictions that issued him or her driver license in the preceding 5 years. The application must also request under statute 24111, National Driver Register database search in any of the results and information to be provided with the railroad consideration recertification. Question 4: How much certified locomotive engineering with the current Canadian Mexican driver's licenses, person with a current Canadian Mexican driver license seeking initial certification or Part 240 disclosure? Such any person must disclose accidents incident described in 111.5 by 1 or 2 involving specified inconvenience with completed state action, Canadian Mexican jurisdiction. 24111 requires the person to report the employee railroad motor vehicles incident with the 24111. 240.11.5, 1 and 2, being 1 and 2, the 48 hours of the conviction complete with the state accident, action canceled, revocation, suspended, denied of the motor vehicle, driver's license operating motor vehicle impaired by alcohol, controlled substance, or refusal to undergo such testing. Required state law when the law enforcement officials seek to determine whether a person operating a vehicle under the influence of alcohol and controlled substances. FRA's interpretation of state action to mean the action or jurisdiction issued with the motor vehicle driver license. A person with the Canadian driver license must disclose the above described actions. Canadian jurisdiction issued licenses. A person with the Mexican driver license disclose the above described actions with the Mexican jurisdiction issued of the license. 240.11.7. Criteria for consideration operational rule compliance data. The general guidance the events listed in 240.11.7 intended with the held the locomotive engineers accountable for their conducting engineers. The mandatory revocation of the specific railroad operational rules were derived in accident data analysis. 240.11.7 paraphrased. The railroad that revokes locomotive engineering certificate shall only consider the violations of its operating rules and practices that involve stop signal violation, excluding hand radio signals, train speed 10 miles an hour more than over the maximum authorized speed, restricting speed as an FAA report or accident incident was required under Part 225, air brake test, main track authority, tampering in Section 219.101. Signals and banners. Preamble to the interim final rules. Final rule gives the element confusion over the failure to respond to signal requiring speed reduction certification consequences under the section. The FRA intends this section to apply to both active stop signals, wayside automatic block signals, cab signal indications, passive stop signals, stop boards or flags or gates. The FRA policy: if the FRA views an unintended use of the banner, this railroad stop banners using the operational testing section in this chapter use the operational testing functional equivalent of the flag position passing an incident fuse the circumstance that required the stop, this should be considered a violation of 240.11c, 11.7e and E1. The definition does not include the hand signal or radio signals. FRA is intended individual railroad operating rules practice would control the device methods of deemed signal indications. The FRA does not intend to limit the learning the wayside signals, which are subject to the FRA signals to control regulations, but in the intent to take the expansive view. Speeding. Expert of the interim final rules, the change will eliminate the confusion with the predicted the fact that the FRA locomotive safety regulation permits a variance of 3 to 5 miles an hour. The speed depicted with locomotive speed indicator the unit actual rate of the speed. That promote the general greater uniformity of how railroads respond to the certification process. The more limited inadvertent overspeed incident ascribable to the factor such variation topographically. Section 240.11.7. of an E2 states that a railroad shall may be only considered violation of operating rules practices that involve failure to adhere to the limitations concerning the train speed when the speed at which the train was operated exceeds the maximum authorized speed at least 10 miles per hour. Restricted speed and more sorts of concerning that become the proper application of 240.11.7E to the certification of engineering for the violation of restricted speed operational equivalent of restricted speed. Generally, restricted speed provides a maximum speed and a conditional clause stating the engineer must be able to stop within one half of the range of the vision. FRA policy, railroads considering all these violations conditional clauses of restricted speed, the operational equivalent thereof, and will cause the reportable accident incidents of the Part 225 incidents as failure to adhere to the speed. Use of the train of the or engine brakes. The FRA regulation was amended with a couple of years and the Part 240 was first promulgated with the avoid ambiguity. The FRA explained that it was revising the language so that exactly provides the only failure to comply with the procedure for the safe use of train engine brakes when testing the train air brakes and initial intermediate terminals will certification consequences required of achieving compliance with the federal regulation in Part 232. The change will eliminate the confusion when the railroad procedure should be reviewed and sufficiently safety related to warrant or the revocation of the provision. Alright, mandatory directive. The term used in the 240 has historically been used in 220. The authority of the conduct of the railroad operation includes a situation with a segment of main track that is occupied without permission authority in accordance with the railroad operating rules. If it does not occupy the segment of the track containing the advisory information such as the yardmaster concerning with the track to use. Authority versus permission. The regulation is intended to ensure the engineer complied with the prerequisite was required to operate the main track regardless of nomenclature. There is no difference in risk to safety following the schematics. The further the engineer conducting the operational area does not change within the word, although there must be differences with the authority between authority and permission in number contents depending on the railroad operating rules in question. They are functionally equivalent to decertification purposes. Alright, 241.19's criteria for consideration data, substance abuse, disorder, alcohol, drug rules, and compliance. Co-worker report. FRA fully supports the volunteer peer prevention programs of the Operation Red Block. The FRA recognizes these system programs provided the excellent means of promoting alcohol and drug-free workplace. For example, the FRA regulations to waive the 9-month eligibility period for the violation 219.101. The violation revealed of the formal co-worker reporting the engineering under the care of substance abuse professional or SAP. A former co-worker reporting provides with a safe haven for the engineer under the care of the substance abuse professional. However, the appointed that with the preamble of the final rule, the FRA believes it's important that standard period of revocation of 219.101 219.101 violations that will not be revealed through the co-worker peer prevention programs. Drug alcohol revocation of offenses. Drug alcohol violations that affect the locomotive engineer's certificate can be as follows. Drug alcohol violations resulting from federal tests only in Statute 241.11.9, the FRA established a fitness requirement that the person who has active substance abuse disorder shall not currently certify the locomotive engineer. Consequently, a person whose disorder would be considered ineligible to hold the certificate until the employee assistance and professional AEAP determines the person is safe operating in other conditions as met. See 241.11.9D. The period is ineligible, unlikely to the revocation period, that there is no set of period of revocation. The person is simply ineligible to return to locomotive engineering status until the conditions are met. Guidance: if the railroad terminates the person's employment, another railroad may offer the employee any assistant professional for the evaluation to meet in any other conditions necessary for the regulation. Section 219.101 and 219.102 guidance: although there may, in terms of revocation is not used in section, identify different periods of the ineligibility violation of 219.101 and 219.102. The FRA has provided that the written guidance of the website that actuates the terms of the federal alcohol drug violation requires the period of ineligibility for the trigger opportunity for the revocation hearing unless valid waiver is signed by the statute 240.307. Violation of 219.101 required a mandatory 9-month revocation. 9. A violation of 219.102 revoke the equivalent a violation of 219.102 will require evaluation of qualified substance abuse professional to determine when the engineer can return to work. Guidance: engineers have potential return to the work sooner under the non-compliance of statute 219.102 and then 219.101 because 219.101 mandates at least a 9-month revocation. Reducing the revocation period, the regulation specifically identified with the locomotive engineer is eligible to have his or her revocation period reduced if an option of the railroad decision entirely up to the railroad's discretion, not the FRA's or the employees. However, the operational practice inspection should monitor the railroad use of the option and ensure the railroad is in compliance with the railroad are consistent with the application reducing the period. Revocation period. Inspectors should ensure the following questions have been considered. What is the initial period of the revocation in 1 year or less? What is the certification denied revocation for the reason of the federal alcohol, drug, and violation? When was the person evaluated, designated supervisor, or local engineer for the proper safety concerns? Inspectors should determine the evaluation of the bona fide safety reason for the non-safety related issues, such as missing calls, working with the rest of the days, etc. Did the person successfully complete a mandatory program training, or the retraining prior the returning to the work? Did the person serve as at least one half of the protected period of the revocation specified in the regulation? Is the railroad using an option of the valid reason? Yeah. Certified locomotive engineering work is enough. The rule address concerns over the situation in which the engineer is found to be engaged with the operational misconduct while serving the conductor brakeman. Typically, the events that demoted with the locomotive engineers working with the conductor will not result with the conductor having his or her locomotive certification revoked. Section C, Statute 24117, C3. It is not the FRA's intent to be accountable with the certification process operational non-compliance incidents that were not serving as an engineer. The FRA's judgment that have too many potential instances where the difficulty of other trained crew members effectively intervene with the preventing operational misconduct with the person that controls the locomotive. Alright, certified locomotive engineers with the DSLE pilot instructors under the title Statute 24011C2. Each railroad required to revoke the certified designated supervisor locomotive engineer's pilot. The instructor will face the appropriate action to prevent the violation. One of the operating practices described in 24117 Regulation Appropriation Act does not mean the supervisor or pilot instructor prevent the violation occurring at all costs. The duty may be met by warning an engineer of the potential foreseeable violation, thus in an audit determination whether the railroad was correct in determination and whether the designated supervisor, locomotive engineer, the pilot and instructor certification FRA considered with the person may be attempted to warn, preventing the revocable event of occurring. They may also be the question whether the violation foreseeable under the particular actual circumstances. Designated supervisor locomotive will not be held capable for taking an action preventing the violation. The designated supervisor locomotive engineer is performing operational compliance tests as doing what was defeated in such tests. Leaving the controls of the operation of the locomotive. An individual who is in control of the moving locomotive is in a position controlling the locomotive if need arises. It does not mean the actual manipulation of control. Therefore, the violation of the rule over a non-certified person to sit in the seat and watch or sound the horn while the engine is temporarily away, even though the controls are not no controls are touched. The same rationale applies to nobody at the controls. For example, if an engineer leaves the seat vacant, leaves the control compartment for any reason while the locomotive is in motion, there is no certified locomotive engineer to take the engineer's place. The FRA considers this a violation. Another example: the engineer may not vacate the seat and use the toilet in the cab nose. This does not prohibit the engineer from exiting the engineer's chair in order to move around the control compartment, but it does not require the engineer to remain personally in charge of the operational locomotive at all times. Alright, 241.21. Criteria of vision and hearing acuity, division acuity, distance of vision acuity. If the employee does not require the section required allowed to waive the regulation certifying the candidate in a way, the FRA allows the railroad medical officer to determine whether the candidate is safe to operate a locomotive train despite meeting of the threshold. Corrective lenses, Appendix F of the Part 240 Medical Standards to Guidelines state the purpose of the appendix to provide with the greater guidelines. The procedure should be employed with the administrative vision and hearing requirements of Statute 241.21, 242.07. Engineers who were contacting lenses should have good tolerance to lenses, should be instructed to have a pair of corrective glasses available on duty. Appendix F, Part 240 provides guidance procedure should be employed with the administrating hearing of the vision requirements. The guidance of the Appendix F regarding the corrective glasses available for the employee with wearing contact lenses not mandatory if it should not be required for the federal observation and federal defect. Reading glasses. The vision acuity standards do not address making certificate for the need of wearing reading glasses. The vision requirements are limited to addressing visual acuity, field of vision, and color blindness issues only. Section 242.23 permits the railroad to anoint the certificate reading glasses restriction if they desire. They can also put the supplemental information on the certificate under corrective lenses if the railroad does not, and it should be clearly indicated that they are required for reading purposes only. Laser eye surgery. When an engineer certificate identifies the employee is required to wear contact corrective lenses, the inspector witnesses the employee operating equipment with required corrective lenses. The employee insisted that his or her eyesight has been corrected due to the successful laser eye surgery. The inspector should ensure the safety public and immediately with the contact railroad managers inform them of his or her findings, and they will be railroad responsible to ensure the employee within compliance with the regulation. After the event, the inspector should do the re-inspection to determine with the proper enforcement. Did the employee contact with the railroad properly with the employee failed to contact with the railroad to inform that he or she had surgery no longer requires corrective lenses noted the certificate. Did the railroad fail to correct the certificate is responsible for the amount of time after the medical record to support the engineer determination that his or her eyesight has been corrected to meet the regulatory requirements of the corrective lenses? Did the railroad take responsibility efforts to ensure the public was not at risk? If the public was at risk at any time, what was the exact risk? Inspector was required to follow up the consequences. Follow up with the concerns documents in the efforts of the inspection report of the compliance is obtained. Inspector should use proper re-inspection source codes. The inspector should generally be treated deficiency unless the employee notified the railroad that their eyesight had been corrected. The railroad ample time to correct the certificate. If the railroad did not take timely action to correct the certificate, a recommended civil penalty then be considered. 241.23 Criteria Initial Counting Education Training Program. Inspectors should monitoring the program in the field in the classroom to ensure the railroad is complying with the training program current on the file, and if the railroad is not providing with the training to field as stated within Part 240 of the program, the inspector should address the concern of the field decision with his or her regional specialist. Any inspector who issued the railroad in the Part 240 written program under the FRA should not take a deficiency against the program with discussion. His or her supervisor. The inspector should take meticulous notes concerning the concerns immediately provided with the information supervisor, FRA staff, and can be a unified approach to the issues found in the railroad program. Class 3 Railroad Training Requirements. It is becoming apparent with the American Short Line Regional Railroad Association, SALRRA, that the Class 3 standard program with the qualification certification logo most engineers may appropriate all records to fall under the classification. The program was initially developed to provide initial training guidance for the limitation of lighting situation operation conducted with this slow speed. Under this program, the total training period required to become a conductor certification engineer is just 3 weeks, 48 hours classroom training, 80 hours on-the-job training, and see the Class 3 standard program, Section 5 of the paragraph A, B, and C. FRA consideration of the program to be baseline model, but to provide the minimum training necessary for the basic railroad operation will not accept the lesser content. Many Class 3 railroad operations are becoming more sophisticated, demanding a great degree of the trained engineers. Track speed are faster due to the successful training maintenance programs. Train size increase. These railroads expanding operations to aggressive seek their share of the shipping market. Similar due to the joint operations, many of the Class 3 railroad operations, national major railroads, which again it dictates the engineer receiving the additional training due to the complex methods of train operation, large trains, and higher speed encountered on those trains. To ensure the engineer training is and demonstrates the actual operations of the engineer will experience on the railroad, the FRA has become working individual with Class 3 railroad whose operation exceed the intended of the Class 3 standard program. When the engineers are expected to operate in more complex operation, most of the connected railroad requires an engineer to acquire the on-the-job training with the stated in that Class 3 program. However, because of the large number of the railroads, the FRA policy is explained below to provide the broader, more consistent means to ensure the engineer receiving the sufficient training type of the operations will encounter. The FRA's policy. The FRA requests the railroad have adopted, used, and in part of the ASLRA Class 3 Standard Engineering Certification Program as whose operation extends those intended with the Class 3 program, considering modification Section 5 of the paragraph C provided for any additional trainings necessary. Specifically, the FRA has recommended with the railroad increasing the student engineer on-the-job training per railroad stated in the program, i.e. not less than 80 hours other than 15 road trips. Accordingly, for example, the FRA recommends minimum of Class 3 railroad whose operation are similar to Class 2 railroads should adopt the SLLRA's Class 2 standard program. The program minimum requires a minimum of 240 hours on the job and has also slightly increased the classroom time. The FRA has taken an approach provided with the evaluation and training program to larger railroads with a similar operation. The FRA intended to address the safety concern with the having of the mandated specifically minimum training programs. The approach inconsistent with the intended design of the regulation, which was set back in the training guidelines, allowed the railroad to latitude to develop the training program specific to their individual needs and operation. Given the past operation, the SLR, the American Short Line Railroad Association members of the FRA, the variety of the Class 3 will amend with the programs according with the FRA received the issue of the problem-specific railroad for the railroad to refuse the voluntary address within the program. FRA intended the service notice with such deficiencies, formal process, disapproval, statute C 24103C. This disapproval process or question of the FRA to the administrator notified the railroad of the information of the railroad of the specific deficiencies on the C Title 24103C1. Under such circumstances, the railroad must submit the program necessary revisions within 30 days after the date of such the notice of deficiency. C Title 24103D. The failure to make a timely resubmission necessary revisions will consider a failure to implement a program. Under the section, the FRA will use enforcement discretion to whether the civil penalty alternative action is appropriate. Section C Title C24011 with the explains the consequence of noncompliance. Appendix A of the FRA civil penalty violation. 241.25 criteria for the testing knowledge. Knowledge testing. The railroad may divide the conducting knowledge testing section, which may be conducted at different times. The FAA recognizes the railroad may have need for the administrative portion of the testing activity at different point of the time. The rule does not prohibit this. The oral written testing, see section 241.25c, requires the testing administrative written form. The rule does not allow the administrator to oral testing of locomotive engineers. 241.27 criteria of the examining skill. The examination of the engineer's skills should be most demanding surfaces in which the engineer will work. It is true that the RCO, if the RCO will handle the 75 to 100 cars, the FRA would expect the skill set test to be conducted at the same level of difficulty. Simulators. The regulation allows the use of the Type 1, Type 2 simulators expanding and examining skill performance. This section does not require the railroad to implementation of additional more than stringent requirements of the locomotive engineer, not inconsistent with the regulation. FRA takes no exception to the use of simulators as a training tool that has been provided with the provisions of the regulation. However, the FRA does not consider the use of simulators to be acceptable substitute for practical experience until an initial person previously untrained. It is not in the intent of regulation to allow certification of locomotive engineers who have never operated an actual train. Outside training organization, non-railroad contractors, specifically Section 241.103 specifically allows the railroad to employ outside training organization to provide initial and student training. The outside organization is not prohibited from performing ongoing continual training. Even though it is not addressed in the regulation, the railroad must declare the submission of the FRA's intent to employ the outside training organization. If the training is conducted in a way the railroad owns trackage, the submission must be described and how the student will be taught the physical characteristics of the railroad. Appendix D of the Part 240. 241.29 criteria for the monitoring operational performance. The certified engineer. The procedure is performed by the designs DSLE. Most of them performed at least once each of the calendar January 1st to December 31st. The operational performance, the observation date should appear on the engineer's certification on his or supplemental documentation. The certificate does not have an indicate the most recent monitoring rides must be can indicate the date monitoring ride was performed for each completed year. Alright, the requirements of the monitoring ride, such as the amount of the time, the number of the miles, should be found in the railroad's Part 240 submission to the FRA. Inspectors should be familiar with these requirements to review the monitoring riding records. So Part C, implementation certification process. Territorial qualification. The FRA received questions for the railroad management regarding the requirements that must be made. The certified locomotive engineers consider the qualified to operate over the specific territory. Some individuals have confused the regulations since the requirements are not covered in single section. Part 240, the all reference to specific provision of the 240 is amended in 1999. CH16 FR 60966, November 8, 1999. Alright, general requirements of regulation expressly states the railroad must initially train and set periodically their re-educate the locomotive engineers to ensure that all ensure that they, 1, remain knowledgeable on the physical characteristics, 2, process the training, handling and demonstrate the territory over which they expect to operate. See Statute 240-123B and C 240-125, 240-127, 242-03, 242-13, 240-31A, and Appendix B. The general rule amended with Amendment 1999 is that no locomotive engineer shall operate the locomotive over the territory unless he or she is qualified on physical characteristics of the territory. Statute 240-231A. Exemption of this general rule, either the requirement of the pilot or allow unqualified, allowed certified locomotive engineers to operate specified physical characteristic operational conditions pose minimal risk. Territorial qualification certification requirements question and answer. The following FRA answers the most frequently asked concerns of the territorial qualifications. Question 1. What are the territorial qualification requirements for the railroad to elect the qualified personnel untrained with the person to the locomotive engineer? The training requirements of the previously untrained person are listed in Statute 240-123. C. What knowledgeable test, skill, and performance tests must be passed. Further, the railroad supervisor must make a certain determination for a person to be considered with the qualified to safe operating particular territory. In summary, the requirements include training statute 240-123C and the FRA approved program prepared from the pursuant 24103. Testing. The engineer may pass a written knowledge test of the physical characteristics of the territory prescribed in statute 240-125C for qualifying the DSLE who must qualify on the territory must determine written engineer is familiar with the physical characteristics of the railroad and pertinent segments of this pursuant to 242.13b3. Question 2. With the requirement that the regulation railroad wishes to qualify the certified engineer over territory in which the engineer has never operated, answer 2. The term qualified is defined in the 1999 amendment of the person, meaning a person who has passed appropriate training of the testing programs required for the railroad and who therefore actually knowledge may reasonably expected to have knowledge of the subject of the person qualifying a certified engineer over the new territory is required in statute 240-231 and is accomplished by concordant provision continuing education in the railroad owns programs 240-123B and appendix B. In developing continuing education provision, the railroad will determine whether the kind of training is appropriate with address such a possible training scenario in the railroad Part 240 program. C240-123 FRA recommendation. Railroad Part 240 addresses the possible training scenarios in which the engineer is transferring to the territory demands of the great training skills and transferring from the relatively flat territory mountainous territory, transferring the territory that allows the operation of extremely long trains that engineers that have never experienced before. See the statute 240-127. Failure to address these scenarios may lead to determination of the program's efficiency. Question 3. With the requirements of the regulation, when the railroad wishes to requalify a certified engineer, the physical characteristics of the territory the engineer has previously been territorially qualified, but is either allowed his or her qualification to expire according to the railroad program nearing the expiration date. Alright, Section 240-123 requires the railroad to address the concern with the engineer's knowledge of the particular territory can be to be over time. Failure to adequate procedure continuing education is a violation of this section. When a railroad previously determined engineer qualified to operate the particular territory, the FRA has permitted the railroad to address the subject continuing the education certification program failing pursuant to 240. The appendix part B, 240, the FRA makes it clear that each of the railroad program must address the familiarization training engineer who has been in the territory for some time with those whose territory has been changed. Railroads have been fulfilled with the obligation requiring engineers requalification on the training of the specified period of the training and be elapsed. But under no circumstance may a railroad wait longer than 36 months to requalify an engineer on the territorial qualification, so in no interval the recertification can be exceeded in 36 months. Although a railroad could be previously territorial qualified and does not proceed an untrained person, see answer 1, or certified engineer who has never operated over the territory, see answer 2. The FRA policies to permit the railroad to perform less formal process long as it processes clearly articulated in the performance in accordance with the railroad is part 240. Question 4. When procedure followed when there is disagreement between engineer DSLE concerning the engineer's territorial qualification. In other words, what are the parties responsible for the DSLE and believes the engineer territorial qualified engineer believes the otherwise? Section 242.31 expressly prohibits the engineer from operating over the territory not qualified in the physical characteristics of the under this section. The FRA could hold the railroad officials, engineers of individual liability in addition to the holding the railroads liable. The railroad may not order a person who is territorially unqualified to operate locomotive the train in the territory. Likewise, an engineer operates over the territory which he or she is qualified in the physical characteristics risk facing the FRA enforcement proceeding with the civil penalties of disqualification of the sensitive service. Under some circumstances, the railroad official to do such as DSLE, the engineer may disagree with whether the engineer is territorially qualified. Dispute may be resolved by checking the territorial qualification records kept from the engineer to see if the person is initially qualified properly to over this territory, checking the engineer's certificate, see if the identification of the territory on which the engineer qualified to determine whether the DSLE has determined the engineer to be qualified on this territory, his or her initial certification statute 242.13b. The railroad cannot be determined through one of those means that the engineer is qualified for the territory. The FRA strongly recommends the railroad not under the engineer to operate under the such conditions. I ordering the engineer to operate the train when the railroad has no basis for the believing the engineer territory qualified is likely to result in the FRA not taking enforcement action under the statute 242.31 against the railroad officials who approved in such an order. If it turns out the engineer was not, in fact, qualified, in addition, the engineer certificate actually contains its training restriction. Railroad requires the engineer to platform service beyond the specified certificate limitation. The action will be violated. 243.05c. Of course, the FRA decision on whether the enforcement action was warranted will be used based on facts issued in the incident. Please note that the engineer is not territorially qualified. A railroad may permit the train movement with an engineer pilot pursuant to the statute 242.31 who may be considered a qualified pilot will depend on the exercise experience of the engineer specified in the section of the regulation. Question 5. What degree of knowledge skills must the DSLE possess to test and qualify engineers over his assigned territory? The regulation outlines the DSLE, the requirements of 241.05b. The railroad shall examine any person considered with the qualification as a supervisor locomotive engineer determines that he or she knows all the understanding requirements of this part, can appropriate test and evaluate the knowledge of the skills of locomotive engineers, has necessary supervisor experience to prescribe appropriate remedial action for the noted deficiencies, training, knowledge, and skills of the person seeking obtaining recertification. If a certified engineer whose qualified physical characteristics of the portion of the railroad on which the person will perform the duties of the DSLE, compliance with the requirements will ensure that any DSLE will be responsible for the qualified engineer, specifically territorial proficient engineer will perform basic duties of the supervisor. DSLE lacks the knowledge and skills required for the engineer operated with the specific territories. The person should not be the DSLE. FRA intends to strictly enforce the requirements of the regulation to ensure that each of the DSLE is qualified to perform his or her supervisor duties. FRA notes that possible lone DSLE performed the required testing, qualifying both of the physical characteristics skill performance simultaneously. However, the railroad wishes to ensure the advantages combined with the requirements must use the DSLE qualified physical characteristics of the territory over which the test was conducted. Compare the 242.13b3 requiring the qualified DSLE to determine upon the completion of the training program that the person is familiar with the physical characteristics of the railroad pertaining to the segment statute 241.27c2, explaining the characteristics of the territory, or explaining the skills of the performance that does not require the DSLE to be qualified in physical characteristics of the territory over which the test will be conducted. Additional requirements of annual operation performance monitoring explicitly allows the railroad program to contain procedures for the permanent DSLE to conduct the monitoring, even though the DSLE is qualified in physical characteristics of the territory over which the operational performance monitoring is conducted. Question 6. Under the condition of the may an engineer operate the territory on which he or she is not qualified. The answer 6 of the threshold issue important distinguishing between whether the engineer question is operation of joint operational territory. If the engineer is operating with a joint operational territory which he or she is not qualified, the engineer operates the locomotive trained with a qualified person as a pilot person. Statute 242.29 qualified person is defined in the section is to mean either by the designated supervisor, locomotive engineer, certified training service engineer to determine with the control of railroad to have the necessary knowledge concerning with the controlling railroad operating rules, to have necessary operating skills informing the familiarity with the physical characteristics concerning with the joint operation territory. Without qualified person pilot pursuant to statute 242.29 F, as long as minimal joint operation defined in this section. 3. The railroad has need for the territorial unqualified engineer to operate the locomotive of the train in any other joint operational territory. The scenario is most common to the others Then, like railroad operations, engineering is operating joint operation territory. Some circumstances do not require a pilot who may serve as a pilot when a pilot unnecessary specifically addressed in 231. And I'm going to take a break right there. We're on responsibility of in joint operations.